Start. The trial court, after framing three issues, the first being with regard to manipulation and fraudulently obtaining the alleged documents, the second regarding the right of the plaintiff respondent to get the defendant appellant evicted, and the third with regard to entitlement of Masonry profits, decided all the issues against the defendant appellant. Stop. A categorical finding of fact was recorded that there is no evidence to prove that any of the above documents were obtained by misrepresentation, manipulation, or by playing fraud upon the defendant appellant. Stop. The plaintiff respondent has proved his right over the property, and since the license of the defendant appellant stands determined, he is entitled to a decree of eviction and payment of Masonry profits, though not at the rate claimed by the plaintiff respondent, for which there is evidence, but at the rate of rupees 1000 per month for the use and occupation of the premises in dispute. Stop para. The leave was granted and the appeal was admitted, probably on the question as to whether the above documents, namely the power of attorney, the will, the agreement to sale coupled with possession memo, and the receipt of payment of sale consideration, would confer any title upon the plaintiff respondent so as to entitle him to a decree of eviction and Masonry profits. Stop para. The aforesaid point was not raised by the defendant appellant through his pleadings in the trial court or the first appellate court, and therefore, the High Court in second appeal held that he cannot be permitted to raise such an issue, and that the appeal, as such, does not involve any substantial question of law. Stop para. The suit as per the pleadings is that of eviction and Masonry profits on the averment that the plaintiff respondent is the owner of the property. Stop. He has claimed ownership on the strength of the aforesaid documents, especially the agreement to sale and the memo of possession, as well as the receipt of payment of sale consideration. Stop para. No doubt, agreement to sale is not a document of title or a deed of transfer of property by sale, and as such, may not confer absolute title upon the plaintiff respondent over the suit property in view of section 54 of the Transfer of Property Act, 1882, nonetheless, the agreement to sale, the payment of entire sale consideration as mentioned in the agreement itself and corroborated by the receipt of its payment, and the fact that the plaintiff respondent was put in possession of. Stop.